We have Mr. Corey Beckles is up right now, and after him, I'm seeing Derek Allen is right here waiting to come on. So we're moving at the speed of light tonight, and I'm going to move out the way and welcome Attorney Corey Beckles as he talks about the three requirements of a will. Get your paper and pen ready. Over to you, sir. Good night.
Good night, Marcia. Good night to everyone. Hope you're hearing me clearly.
Yes, I am. I am.
All right, yes. Right, so I'm going to get right into it. Three requirements for a valid will. Right, so the first, we need to have capacity. So the first requirement is capacity. And there is an age requirement to prepare or to sign a valid will. And that age requirement is 18 years of age. So you must be at least 18 years old to be able to make a will. Now, there are exceptions to every rule, Marcia, but that is for another program. We will get into those exceptions as it relates to that age requirement. But capacity, so a capacity as relates to age, but also capacity as it relates to soundness of mind, what we call testamentary capacity. So we will see in a will, if you look at an example of any will whatsoever, you may see, well, it is not necessarily placed in every will, but you will find that there are some wills that contain the words being of sound mind. Being of sound mind, I give this, I give that in a particular will. So you need the testator or testatrix, the person who is making that will, must have testamentary capacity. They must have soundness of mind. They should not be suffering from any mental deficiency whatsoever. This also brings me now to another aspect of capacity. So what happens, Marcia, if you have a testator, testatrix, someone who wants to prepare their will, but they are faced with a disability such as being blind? What do we do then? They can still make their will. They can still give instructions to an attorney for their will to be drafted. However, when it comes down to the part of that will where they have to sign, where persons have to witness, it has to be shown inside of that will that it was read over to them. So that person who is blind, any person who is reading their will must be assured that they knew the content of the will. So in order for them to know the content of the will, it has to be read over to them. And this has to be stated in the will that it was read over to them and they approved of the content of the will. Because we have individuals who are not necessarily blind, they're not fully blind, but they may have some eye issues, some eye serious eye issues that is causing them to lose that capacity to see. They can still get their will prepared, but you must place within that will, you must assure persons who are reading that will that that individual was able to understand, to know the contents of the will. And that leads me now to the second requirement. And that second requirement is intention. So the testator or the testatrix must possess the intention. They must have intended to make that will. Why is this important? Because a will is one of the most powerful documents. And this a will speaks after someone's decease, after someone's death. So that person who is now deceased must have intended to make all of the what we call dispositions, all of those the dispositions in the will. I give, I devise, I bequeath my property, as the case may be. They must have intended to do so. And usually, when you are assuring, let's say someone is challenging the will, and their challenge to the will is that the testator or testatrix, as the case may be, they not approve of the content of the will. They never intended to give what they give in the will. Sometimes it is always best to advise individuals. If you are going to make a gift that may seem irrational, there are testators or testatrix that have 3 children, or they may have only one child, Marcia, and somehow someone who is unfamiliar, someone who seems to come out of the blue, is being given property in the absence or in substitution of that child. Something has to be wrong there. If that parent is going to do something as drastic as that to disinherit their only child, it is always advisable that they place the reason why they're doing this. Place the reason within the will why I am disinheriting my son. Because any person who is looking at the will after that person dies, any person who is looking at the will and it goes to court, and the court receives evidence that this parent, that the child, sorry, was taking care of the parent before they died. The child was always in the parent's life. The question will be asked: why did this individual make this important decision? This decision that involves the destiny of their property. Why would they leave out their only child for someone who is practically a stranger?
Mhm.
And when the
So,
court, yeah, go ahead.
so question here, how can you, the person, if the person is died, that because it will, it's after the person has passed on, how do you prove intent?
Right. So the person, the person who is, I would say, the stranger in this circumstance, the stranger who is benefiting from the will have
Mhm.
to prove that
Ah.
there was no what we call undue influence.
Mm-hmm.
So any person who is putting a will forward for that will to be probated, they must show that everything was done, that the will is a valid will. And if there's a challenge to that will, and they find themselves in the court, they now have to let the court know what are the circumstances. Sometimes you may have to invite the attorney at law who actually drafted the will,
Mm-hmm.
because the attorney at law will be able to give evidence as to the circumstances in which the will was drafted. And again, as I said, even if the will does not contain the reason why the parent is disinheriting the child, that only child, the attorney may be able to give the court some measure of clarity as to why the parent would do or would make such a decision.
Yes.
But if that decision cannot be explained, if there's no reasonable explanation for that decision, sometimes you will find that that will could be deemed invalid. It is not an exact science, Marcia, but
Mm-hmm.
it all depends on the circumstances. So when I gave the circumstances of that child always taking care of the parent, that child always in the parent's life, the parent may even would have done a will prior. Because a person can have more than one will. The parent could have done another will before this last will, giving everything to that child. So when the
Mm-hmm.
court looks at at the circumstances, the fact that the child was always in the parent's life, the fact that there is a previous will giving everything to their only child. Now this last will and testament, something seems fishy,
Straight. Okay. Got you.
because the circumstances show that there really is no reasonable explanation why the parent would disinherit their child. So just to answer your question, it all depends on the circumstances. And even though the testator is no longer there, even though the testatrix is no longer with us, the court can still look at all of the circumstances. Because
Mm-hmm.
the child will be given evidence. You may also have evidence from the attorney at law. And you may also have evidence from family and friends, family members who may have heard the parent saying, well, anything, when I die, I'm going to leave everything to my son. All of this is evidence that the court can use to make a decision to determine whether or not the will is valid or invalid in the
Right.
circumstances.
Intention.
Yes, intention is very important. I know the third requirement is what we refer to as formalities. So there's certain formalities for a valid will. The first one, the will must be in writing. The will must be in writing. Now, I know we are familiar with a lot of TV shows and movies where a person may leave a video will. A video will or will done through video, or even a will done through audio, if that's even possible. Um, we see these things happen. We see these things occur on these TV shows and movies. But a will must be in writing. For a will to be valid, it must be in writing. And I can't stress that enough.
Mm-hmm.
Now, what happens if it is the last moments? Person may be on their deathbed. Now, of course, they may not have the opportunity to call an attorney to draft their will. What happens if they take a pen and they write their will by hand on a piece of paper or a scrap of paper? What happens then? So the formality of or the formalities for a will are suspended when we are dealing with a will that is written in the handwriting, written throughout in the handwriting of the testator or the testatrix.
Oh, okay.
Right? So because the testator or testatrix is using a pen, they're using their own, is in their own handwriting. So because it's in their own handwriting, the law does not require all of the formalities that it requires from a document that is drafted and printed, that is typed out and printed. One such formality other than the writing is that it has to be witnessed.
Mm-hmm.
Every valid will must be witnessed. And it
Right.
has to be witnessed by at least two individuals. And those two individuals must witness the testator or the testatrix signing that will. So really and truly, there should be at least three individuals. Whenever a will is being signed by the
Mm.
testator or testatrix, there really should be three individuals.
Three. Right.
Well, it could be four if the attorney is not a witness. But usually the attorney is a witness. The attorney who is actually preparing the document is a witness. Along with if it's done in the attorney's office, it could be their secretary, the attorney's secretary or assistant. So there really should be at least three individuals in that room. The first individual is the testator or the testatrix. The other two individuals are the witnesses,
Two witnesses. Yes.
right? So the two witnesses must see the testator or the testatrix sign the will. They must be able to see that with their own eyes. And they also must be able to attest to the fact that on a particular day, on the 6th of July, 2026, I was at the office in Bridgetown, at the lawyer's office in Bridgetown, and I saw Testator B sign his last will and testament. And he
Mm-hmm.
signed it in my presence. So everything must be done. All signatures must be done in the presence of the testator. And also, the testator must be in the presence of the witnesses when they're signed. So everybody should be in the presence of each other. So the witnesses are attesting to the fact that they saw the testator or testatrix sign. Also, the testator must be there to see the witnesses sign also. Everything is done in the presence of each other. And those are the formalities, really, Marcia.
God.
But
Okay. So those are their witness and writing, and you must have at least two witnesses. So
correct,
essentially, you have three persons,
correct.
in that room or wherever you are. Yes. And those are no. We literally have 10 minutes because I am trying to make up time now.
Right.
Um,
Understood.
so somebody's asking if that will is called a holographic will. I guess a will that is done by video, but it's isn't that
Not
just
video,
movie
but
or
handwriting. Once the will is in the handwriting of the testator or the testatrix, we refer to that as a holographic will.
I see. Okay.
Right. And the holographic will, or the will that is done in the handwriting of the testator or testatrix, does not require those formalities, as I said before. So then there don't need to be any witnesses when there is a will throughout that is written in the handwriting of the testator or testatrix. Because as I said, sometimes those will, or most often, those wills are done when the testator really has no choice. There's no one around him or her. They want to make a will. They find a pen and they find a piece of paper and they jot down what they want their estate or who they want their estate to go to. So the law approves of such wills that are done totally in the handwriting of the testator, and the law does not put a burden on the testator for the testator to now go and find witnesses to witness his handwriting or witness his signature of his own will.
Yeah, John Clark saying very informative. Listen, I didn't know a holographic will. I thought, you do holograms. I thought that's what it was. A video was, the video thing. Thank you, Judith, for that. Make it saying that because I learned. I every time this show on a Monday night, especially Monday night, I'm learning
Right.
something. So holographic will did not know about that. I'm waiting to see if we have any other questions here, but go right ahead if there's anything you want to tell us in the next 8 minutes.
Right. Yes. So, um, as we and I'm going to give just a sneak peek of next week, God willing, we're going to be looking at different kinds of wills next week.
Okay.
So we have many different kinds of wills, and it's very important when you are deciding, you make that decision that you want your last will and testament to be prepared.
Mm-hmm,
It is always best that you are aware of the different kinds of wills
mm-hmm,
that are there. Also, especially as if you are married, there are specific wills for persons who are married, for persons who want to ensure that their husband, wife, as the case may be, their spouse are taken care of. Right? So we will go into that next week. But while
yes.
we're still here, we still have some time.
Yes.
Um, right. So I see the comment here, and I know a holographic will is legal in this jurisdiction.
Mm.
Yes, right. So correct. So as relates to the
There's-
holographic will,
yeah. Okay.
yeah, go ahead.
Continue, and then you can. I know you've answered this several times, but go ahead.
And can I leave my portion to someone else? Yes, before the yes, you have the capacity, as long as you have the testamentary capacity, as long as you are not suffering from any debilitating or mental deficiency, you have full right to leave your property, your estate to someone other than your children. However, if you have a child who may be suffering from who not suffering, but who is under disability, a child who has to be taken care of every day of their life. That child is referred to as a dependent. Even though that child may be an adult, that child is still a dependent.
Mm-hmm.
And if you are going to make your will, prepare your will, you have to provide in your will for your dependents.
Oh
Any
wow.
person that is dependent on you, any person that was dependent on you prior to your death, you cannot disinherit them. You must make provision for them in your will. And that's important. Very important question.
Wow. So that's where it would be contested.
Correct. Correct. Yeah. So
Wow. Very.
you can't leave that child, even though the child is an adult, you cannot leave them without support. You cannot leave them without support.
So the
According
court
to the law.
will the court will then decide.
Yes, the court will decide.
Oh my
If
gosh.
it is that individual, that child, because a child may have their different disabilities, their physical disabilities, as the case may be, their mental disabilities. Someone, depending on the situation, depending on the gravity of the situation, someone will have to represent that child in court to
Mm-hmm.
challenge that will, because what we call the Succession Act of Barbados, which
Mm-hmm.
deals with estate matters and distribution of estates, that child will be considered a dependent. That child was relying on you or relying on the parent prior to the parent's death, and the parent cannot disinherit them. The parent must provide for them in their will. Another
Mm-hmm.
issue also is that even though you may have a child that is not necessarily under any disability whatsoever, or a family member, if it is proven that you were taking care of that individual,
Yeah.
every month you were giving them money, sending groceries. If it is proven that you was doing this on a consistent basis, there
Yes.
is the possibility that that child can also challenge that disinheritance in the will.
Oh, wow.
There is a possibility. So
That's it.
dependence is not just based on the fact that you may be under some mental or physical disability. The child may be under some mental or physical disability, but dependence is also, from a factual standpoint, that person was depending on some financial gift every week, every month. I know that that
Mm-hmm.
person is no longer here. That person is still dependent on the estate. In this case, it will be on the estate. And that person, I'm not saying that in every circumstance it will happen, but that person can challenge their disinheritance in the court.
In the court. There's another question here, very informative. There is a trust fund better than a will.
Um, the trust fund has its benefits. There are advantages to a trust. There are benefits to a trust. There are benefits to a will also. There are also disadvantages to a trust, and there's also disadvantages to a will. Whether or not you should do a trust or whether or not you should prepare a will depends on your circumstances. It depends on how many assets you have. It depends on how many beneficiaries you have. You may have a business, a company. You may have shares in a company. It all depends on the extent of your estate, and that will determine whether or not the trust is better than a will. But I wouldn't tell you that one or the other is better than the next. It all depends on the circumstances. For example, there's circumstances where a trust will be better if you want to protect your assets or keep your assets in your family line from generation to generation. The trust will be, of course, that will be way better than a will if that is your intention. But a person who doesn't intend to keep that particular property in their family line, it is better for them to make a will. But if you want to keep that property in your family, the trust is better in those circumstances.
Yes. Well, there's a message here from Rosalind Corbin. And by the way, Miss Corbin, if you're listening, I sent you a message about 2 weeks ago, I think, or a week and a half. And I'm wondering, I don't know if your number has changed, but I haven't heard from you. But she's saying it's a practice of posting handwritten will back to self still done. Oh,
Right. I am not certain if it is still done, but what I can say is that it still doesn't, even if you don't post it to yourself, the handwritten will or the holographic will still be valid in the circumstances. I guess the person who is posting the will back to themselves believes that that will have some benefit to them, showing that there is some intention on their part for that will to be valid. And that is fine. That is all well, and that is fine. Nothing is wrong with that. But even if you do not post the will back to yourself, that holographic will still be valid in the circumstances. The main thing following from that question is that someone can find or locate that will. That really is the most important part, because handwritten documents, especially on a piece of paper that may look unassuming, could be easily disposed of. You can easily dispose of a piece of paper that has handwriting on it,
Yeah.
than a document that says drawn and prepared by an attorney that has this is my last will and testament and is on
Yes.
legal size paper. But a paper that is just it may be what we call foolscap paper. It could be on a sheet from a exercise book that can be easily lost
Right. Correct.
and sometimes easily destroyed. So it's very important. I guess that what Rosalind Corbin was referring to is the fact that posting it back to yourself may be a way to keep the integrity of the document itself,
Yes. Yeah.
right, and to
We do
protect
that. We
it.
do that with copywriting as well. Sometimes if
Correct.
you set your writing, but can you believe? Oh my goodness.
Yes, we all the time. Yes, all the time.
Yes, I robbed you of 5 minutes because we're gonna, we're getting, it's getting late,
Right.
and we had some technical difficulties at the top. But Mr. Beckles, again, another tremendous session, and I thank you. I personally thank you very, very much, and I know the others, the viewers as well. Thank you so much for joining us and for the
You're
wealth of
welcome.
information.
Yeah, thank you very much. Have a good night,
Yes,
everyone.
see you next week. God bless.
Yes. All right. Have a good night.
Yes, sir. Thank you. Yes, bye.